So, okay, Jim, tell me about what's going on out in BC in regards to this whole pronoun issue. Because I'm in Ontario, so we don't have exactly the same thing. Although, of course, pronouns have been a cultural issue for a long time. But in your case, because you're practicing law in Victoria, right?
Yep.
Okay. So in criminal law, right?
Yes.
So what is it exactly that happened?
Right. And in fact, Ontario did have a kind of similar brush with something that happened a couple of years ago that I want to get into. And we actually thought we really dodged the bullet here in BC, only to get struck right between the eyes, I think. So what happened is that in mid-December, these notices or directives came down from the provincial court and the Supreme Court. So in British Columbia, the lowest court level is provincial court. Then the trial court level where you can have juries, that's called Supreme Court. In Ontario, it's called the Ontario Court of Justice, or Superior Court. Right? Is that right?
Well, BC it's interesting because you call it Supreme Court of BC, whereas in other places it's called either Queen's Bench in the prairies and then Superior Court in Ontario.
Superior Court, right. And Court of Justice is your provincial court in Ontario. So anyways, we have provincial court, then we have our BC Supreme Court, then we have our Court of Appeal, and then the highest court is the Supreme Court of Canada, of course. Anyways, the provincial court and the BC Supreme Court came down with these two directives way out of the blue. Nobody anticipated them. There had been no discussion beforehand that we now, when we introduce ourselves in court, we're supposed to also offer the quote unquote correct pronouns or the gender pronouns that we want to be addressed by. And as well, if we introduce anybody in court, like our client or maybe some support people or witnesses, anybody that we bring before the court, we need to also proffer their quote unquote correct pronouns. The
main reason for that would be for the court reporter, correct? Because if there's transcripts and so on, that they need to
transcript. I find that word transcripts a little kind of offensive. Just kidding.
Okay. Well, I didn't intend to give offense, but you're certainly welcome to take it.
Right. No. Okay. Trans anything is a little contentious these days. So
are you just making that up, or is that actually something that's happening?
No, that was a joke.
Okay, because you never know. Like we're living in Pospos Law, I think it is, that you can't tell a joke from the truth anymore. Okay.
Absolutely. No, I don't think that's the reason. I don't think it's for the court reporters so much. In fact, no one's even mentioned that. No, it's supposedly because it's kind of premised on an idea that is floated in some of the explanations that the provincial court has offered for why we're doing this. The Supreme Court hasn't done that, but the provincial court has. And it's the idea that nobody can know what to call someone else, how to refer to them either in the second person or the third person, based simply on their voice, their appearance, their name. That leaves us just totally in the dark. I don't know, Diana.
So they're offended by the presumption that you know somebody's gender, right?
That's right.
But there are legitimate cases in court where it could become relevant. So if somebody, say, switches gender from the time of an alleged offense to the time of a trial, then you would have to identify why the person, but then that creates problems too, because you've got, say, a complainant, let's say a sexual assault trial, where a complainant is saying that they were sexually assaulted by a male. And then now the person is saying that they're female. So then a person could potentially be asked to refer to a person who assaulted them with a penis as female.
Crazy, huh? Yeah, that's right.
That's the problem that I have, is that, I understand that there's the courts are designed to be very respectful, right? There's all these titles that people have, and there's ways of speaking that they are meant to show respect and to try and prevent things from turning into aggressive fights. So you call each other my friend and so on, right?
Right.
So I understand the idea of respect, but there's serious practical issues that I don't think have been thought out very carefully.
Yeah, well, there's a lot to think and say about this whole thing.
But the problem right off the top is that it's mandatory, that you're being compelled to state your pronouns as if it's an
Absolutely.
issue. And some people, I think it's been pointed out, may not actually want to publicly announce that they have a pronoun that's not expected. So
That's one whole concern. There are a whole lot of people that are quite into, if I can use that term, that preposition. They haven't come after prepositions yet. That someone's quite into this whole kind of scheme or template of gender terminology and kind of like a heightened, more complex and sophisticated, nuanced way of using gender pronouns. Even if someone's quite into that, you're absolutely right. There's a whole concern that they can be quite into it, but the idea that they're compelled to have to announce themselves or describe someone else, that in itself could seem really invasive. In fact, there's something quite funny that I want to point out kind of right at the outset so I don't forget it.
mm-hmm.
My understanding is that this whole kind of program came about either at the instigation of the Sexual Orientation Gender Identity Committee of the BC section of the Canadian Bar Association, or—
That's a mouthful right there, hey?
I know. So this is a group of people that are, as the name describes, this is a Sexual Orientation Gender Identity Committee. And either they're the ones that asked the courts to do this, or the courts came to them for advice on how to structure this thing and how to deal with it. They're the only ones, the only people apparently that the courts ever consulted with before they dropped this on the whole profession. And in fact, on everybody, on the whole public, anyone that accesses our courts. This isn't like a private rowing club. This is the courts of British Columbia. Anyways, so you have this—
Just for a moment though, are they trying to say that there's like judicial independence issues, and that's why these types of meetings go on behind closed doors, or is there any legitimate purpose?
That would be a criticism that I would have as to how did this happen? You know, where was the consultation process? And in fact, I'll describe that to you in a minute. I actually reached out to the judiciary and they got back to me and they told me, they confirmed that they'd had this consultation, implicitly saying that they'd done it with Sojik. They're very happy with the advice that they got. The point is that nobody else had any part to play in this, as if we're not stakeholders in the way we think of ourselves and how we describe ourselves. Let me explain a little bit of what's happening here, what I think is going on a little bit, and the concern that I just wanted to kind of tell you about before I forget.
Right, okay.
So this whole thing, these notices, these directives are premised on some idea that there's a problem to begin with, that there are all of these people, they're not comfortable with the gender that they might be considered to be. And so they want, it's not enough for them to have the opportunity to be able to correct that in court and say, by the way, Your Honor, I just want you to know, I don't like to be called Mr. In fact, I like to be called Miss, or I'm not sure what I want to be called. It changes day to day or whatever. And when I'm referred to in third person, I like to be called they, them, or Z, or whatever I've chosen today. The idea is that it's not enough for that person to be able to have the latitude from a respectful court that's going to listen to them and try to comply within reason with their requests. The problem is the very fact that they would have to do that, the very fact that they'd have to kind of come forward and say that is onerous. So
they're identifying themselves as unusual and they feel sort of marginalized is, I guess, the complaint.
Yeah, exactly. So the idea is that if we all do it, if we all announce our pronouns, they won't stand out and it'll be one less opportunity for them to feel singled out and embarrassed. And in fact, I've seen in webinars, several webinars that the Canadian Bar Association has contributed to about these kinds of issues, I've actually seen some of the leaders of this group say something to the effect of, for us cis or kind of normal gendered people, I'll use that terminology, they use normal a certain way, I'll use it. Let me just say this, for us normal people,
By normal, you mean
This is like a
majority,
tax.
right?
This is like a tax. This is like a tax. This is something that we should do. We should be happy to do it. We should be happy to kind of give our gender pronouns, because that way we're showing our allyship with our transgender friends and all of that. So that's kind of part of the whole scheme. We all do this. Nobody stands out, and transgender
Well,
people, yeah.
except for that, it's impossible to not stand out when you use a pronoun that previously didn't exist. So like you mentioned sir and Zim and things like that. It's impossible to not stand out. And then I've recently now encountered a problem with the plural pronoun, because you have to be very precise in the way you word things in applications, in submissions, and it's important to clarify. I mean, if you look at cases, let's go away from sexual assault cases, even contract cases, I came across a number of times where the use of a plural pronoun ended up affecting the meaning of a contract, right? Yes. So there's that aspect, because of course, in law, everything is across the board. It's not just one type of trial that you're going to be making this rule for. And then for me, I was looking at how would you say that a complainant's credibility was severely compromised and affects their reliability or their credibility. And when you use the plural pronoun, it actually kind of implies that you're saying all the witnesses had credibility and reliability problems.
Could do.
Right.
Could do.
So, I mean, there's ways to not actually use a pronoun. So you could actually just say, the complainant this or the complainant that, instead of saying, him or her, things like that. But there's definite issues where even one of the witnesses that was being interviewed was referring to this person as they, them, and the police officer was getting really confused. It was like, are you talking about this person, or are you saying that there was more than one person there?
Funny. Right? Yeah.
So okay. It's not an issue of what they want to be called. It's an issue of how many people are involved in the statement that you're talking about.
Yeah, that's right. You know that's right. Oh, yeah, I find this all offensive. How presumptuous of someone to think that they could go to the very heart of our language and just take it upon themselves. There's so many things about this pronoun thing that disturb me. First of all, the idea that we have pronouns. I don't think that we have pronouns. Pronouns are like this kind of unique thing in language. I don't have my pronouns. I always asked once, was prompted by a judge on New Year's Eve to give my pronouns. And I said, I don't see it that way. I don't have pronouns. You can call me whatever you want. It's worked all my life. I think it'll continue to work. I don't see a problem. She wasn't very happy with that, but we carried on. But that's true. I don't think that we have pronouns. I think it's very presumptuous for people to think, in order to kind of further the grist for the mill for some ideological kind of campaign that they have, that they're just going to seize a big part of life, the way we speak, and just commandeer it with this kind of ideological kind of.
Well, I think the question is, like, you have to really look at what's the purpose and how far can it go? Like, what are the limitations? Because I just saw online an article about people using nouns as pronouns. And so then you get into,
really?
You have to look at the concept, and they were using things like princess or, princes or something else. Like, I don't know, ways to combine both genders into the noun that they're choosing, or they're, sort of fan oriented things. So people who are really into vampires want to be called vamp or whatever, right? And they're trying to find ways to use that for pronouns, which you mentioned, like what are pronouns? It's a way for convenience, where you don't have to use a person's full proper name every single time you reference them. And so, but if you start using nouns, just think somebody could say, my pronoun is judge.
Yeah, totally.
Right. So now we've got two judges in the courtroom.
Yeah. And that sounds funny. It sounds insincere. It sounds.
I'm not joking. I'm not trying to be facetious. I'm saying this is a serious problem.
I know that. I know. My point goes back to something that you said kind of right at the outset when I said, made my little joke, which is that, like, we're into such a realm of kind of ludicrousness and unreasonableness without a sense of humor, without a self-reflective sense of humor, which is a bad combination, that you're right. It sounds funny, like the idea believe me, when these pronouns came down, I spoke with a lot of my colleagues and everybody had little jokes. I'm going to call myself kind of just what you said, my pronouns, Your Honor. Or different things. There are lots of jokes on that level, but you never know when someone's going to take that seriously, and suddenly they're staring you down with the threat of a human rights complaint behind their head, and you're going, okay, sure, judge, or whatever. So anyways, the pronouns come down. They're really bad because what they say is that everybody's got to do this, and if you don't do it, the clerk of the court will prompt you. As if like suddenly the clerks are kind of raised to this level of kind of party apparatchiks, little enforcers.
Well, I have a bit of sympathy that if somebody's responsible for recording the events, that they could end up being accused of some sort of hate crime because they didn't record, something to do with the events, or like the transcripts and so on, or the fluid scripts, if you want to call them that. That person has to be concerned about opening themselves up to some sort of a lawsuit or a complaint or something like that. Sure. It's possible. I don't think that's really what's going on, but
no. I had a case. It doesn't happen often. It certainly doesn't happen anywhere near as often as if I can say, the trans lobby, the people that are kind of really into this. Those people suggest that the numbers are much higher than I think that they really are. In my experience, it is very rare that there's kind of a trans person or someone like that needs some accommodation in court. But I had a case a few years ago where a young store clerk was a witness in a murder trial that I had. And I think that person was transitioning. I didn't know, they're very kind of tomboyish looking young person. I can't remember which way they were going. They explained it. They explained it on the stand, and it was no big deal. And I'm caustic, and I've got a sense of humor, and I sometimes say things without thinking. I was able to control myself. There was nothing there, nothing but, like, Canadian courts, very civil. I mean, people are very respectful of one another. So
when it's legitimate.
What's that?
When it's legitimate, right? So
yeah.
But there's and trans, I think, is fairly well understood. So, that is a situation where a person is saying that they are a particular gender, right? So when we get into this new thing now where there's fluidity, you could be in a situation where on day one, your witness is female, and on day two, they're actually male that day.
That's right. And if that sounds funny, I'll stare at you and I'll say, what's so funny about that? And you're going to think twice before you try to explain what's so funny about that, because everything's like the ominous specter of criticism from this kind of woke kind of
well, they're very litigious too.
Yeah, totally.
So but then my first thought when the announcement came out about the mandatory pronouns in BC was one of the things they could do if they want to accommodate for some of these new pronouns and things like that, because everybody understands the male female switch on transgender. That's not the issue now. But I think that they could just do something at the beginning to say, if you happen to be misgendered, then we hope that you understand that it's not intentional, right? That sometimes it's difficult to accommodate language in the course of speaking because you get like rhythms to things, especially in cross-examination. And I had to look it up, but if you've got a plural person, their appellation is, instead of Ms. or Mr., is mix.
Yeah,
right?
That's part of the new directives. They offer mix as an alternative to Mr. or Miss or Mrs.
Right, and that's something that, whereas quite often if you're cross-examining, you're going to be saying, isn't it true that you did this certain thing, right? So you isn't the problem, but you usually refer to them with their surname.
What if you take it out of like the sexual, take it off the sexual spectrum, and what if someone has a different kind of identity issue where they don't identify as a single entity, and so the idea of
that's the they them, yeah. but they still use you. I find that strange that people that say that they are a plural, they want other people to accommodate because there's only other people that have to do it. When referring to themselves, they don't say we.
Right.
Which they ought to if they're plural.
Right. So Diana, there's this whole thing happening just kind of on the face of it. It's an issue, how we're going to deal with it, whether there was a problem to begin with. There's a problem, the fact that there was no consultation with the bar. I wrote to the judges here, the chief judges, and asked them if it was possible that we can open a conversation about this. I pointed out to them that there's even SOGIC that is kind of pushing this agenda. They have webinars where they're giving completely contrary advice, where they say pronouns are really important. You should always be asking someone what the pronouns are, but never in public, which flies in the face of doing it in court. So I write to the judges, say, can we have that discussion that you kind of bypass? And they write back to me and say, don't write to us again. Thanks very much. We're happy with the advice we got. So there's all of this issue on the face of it. There's a question of how much it's going to be enforced and all that. But you know what really interests me? What interests me is what's behind it. The bigger social, cultural kind of wave that this is riding in on. And I think that it's part of like a real kind of insidious, power-grabbing kind of woke agenda to just control. It's like to undermine people's sense of naturalness, confidence, and to control them. And this is compelled speech. It's all bad. So that's why I make a big deal about it.
You mentioned an event in Ontario that you've been thinking that BC dodged a bullet. What was that incident? Where I know about like the Bill C-16, I think it was, when they originally added gender identity to Section 15 as a protected class of people, but that was obviously like legislation for all of Canada. It was just a lot of Ontario people who were taking exception with it, right? The whole Jordan Peterson thing, and an awesome lawyer here named Jared Brown got involved as well. Yeah. So, is there something else that you were thinking of?
I'm talking about something else. I'm talking about the statement of principles.
Right. Okay.
So for any viewers that aren't familiar with it, or just for a nostalgic moment for those who are, a few years ago, the Ontario Law Society came out with this directive without any consultation that every lawyer in the province, for their annual declarations, had to write in their own words on paper some expression of their support for the concepts of diversity, inclusivity, and equality. Kind of the buzzwords of this kind of woke kind of agenda that's happening today that we could discuss and whatever. But the point is that every lawyer had to write down they supported these things and very fulsomely kind of declare their love for diversity, inclusivity, and equality. They didn't have to show it to anybody, but on their annual declaration, they had to swear that they had done so. They could put it in their desk and just leave it there. And I guess the idea was that if you ever later said that you took issue with any of these conceptually or any which way, you are, if nothing else, a hypocrite. And so they wanted everybody to do that. They thought it was important.
But which is kind of offensive, because as an officer of the court, you swear to uphold the rights of all people. So you're assumed to be operating under those principles. So forcing you to make a declaration means that they think that you might be lying or something.
That's right. That's a good point. Or they just want to dig a little deeper. They want to just kind of grab you a little bit further. And
you don't know how they're going to hold you to account for whatever they determine it means later on, I think.
That's right.
The concern.
And it doesn't leave any margin for the idea of being like a Voltairean lawyer who says, look, I hate this law, but I'll swear I'm a sworn lawyer, so I have to kind of comply with the law, but I hate it, right? There's no room for that. There's no room for saying that I personally think this whole agenda is all wrong, but I'm an officer of the court and I comply with the law and all that. There's no room. They want to take that away. So Bruce Party, he's the guy that I know that originally brought this to everybody's attention. Really great guy, really smart.
Bruce is amazing. Yeah.
Yeah. Yeah. I think
Law
Carleton,
professor at
law
Queen's
professor.
University.
Is it Queens or Carleton or Queens? I think
No, I think
Carleton.
he's at Queen's, as far as I
Okay.
know. But I'm sure he'll let us know if we're wrong. But he
Oh,
writes a
great.
lot of articles for like National Post. I think he's been published in
Yeah.
a bunch of other
Yeah, that's
things.
what happened. That's where I first learned about this anyways. He wrote some really good articles about how just kind of unfair this was and unnecessary and unfair. And it helped, I think, mobilize a whole grassroots concern within the law society, within the whole profession in Ontario. And some lawyers took it to the benchers. The benchers are the elected governors, or the lawyers that kind of oversee the law society. And there was a bencher hearing, and they were asking, could there be room for someone to be a conscientious objector, if you will? So I don't want to do this. I'm just not going to do this. And the benchers said no, there wasn't. So everybody had to comply. So what happened was that there was, at the next big province-wide election, there was kind of a single issue mandate amongst a lot of small town lawyers, I think, for the most part. And they rode into power by a hair. It was a close vote, but they won. They kicked out the more woke kind of center of power lawyers from in Ottawa, government guys and the Bay Street guys, and they took over control of the Law Society, and they got rid of the statement of principles. And that's a bullet that I thought that we dodged out here in BC.
That was a huge campaign called Stop SOP, because SOP is the statement of principles. And
right.
Lisa Bildy, an incredible lawyer, actually, who I had the opportunity to meet and talk to around that time, she was actually the big mover and shaker to get that campaign going. She did incredible work. And they made a really good point, although it's my understanding that the issue hasn't gone away.
No, I'm sure that it hasn't. I'm sure that, like, if the power structure just kind of teeters in the other direction at the next election, it's going to come back full force and maybe stronger than ever. None of these issues go away. You know why? Because at best, all that we do when we defend against them is push back to some sort of neutral, safe position. And nobody pushes further. Nobody pushes harder to actually attack those who are trying to kind of undermine our freedoms and our autonomy this way. That's too dangerous.
Well, I know.
No one wants to do it. I don't want to do it. I'm not doing it, am I?
I mean, it sounds so nefarious, but I mean, the problem is that people in their really oppositional positions, they're like really, and it gets quite vitriolic, which I definitely saw going on during that whole bencher election. The horrible things and attacks that were taking place between lawyers, who otherwise would be calling each other my friend in court. But they actually believe that what they're doing is for a good reason, like that their intentions are good, and they truly believe that this will make society a better place. Like, yes. Where it comes across very authoritarian, I don't think that, these are people who are saying we should live in an authoritarian state and I should be in charge, like they seriously do believe in what they're saying. But I recall, it still really bothers me seeing cartoons of old white men being taken out of courthouses in bathtubs. There was a cartoon where they were talking about it's time to get all the old white men out. And it bothers me because our judges need to not be attacked the way they are in the media and in public, so that they're free to make proper, neutral decisions without being concerned about being reported or accused of being racist or misogynist, or they feel like comfortable that they don't have to make decisions to avoid personal risk, if I put that properly.
Yeah. But even if they have that, even if they're given that kind of there's some sort of a protective moat around them that acknowledges the importance of judicial independence and all of that, they're not living in a vacuum. They're living in our society, and they're still getting affected just like everybody else with all of this kind of woke propaganda constantly. And it's affecting everything. You did a podcast with James Lindsay a little while ago, and he made you were talking about Canadian law. In fact, that's how I discovered you. I think it might have been through that podcast, because I'm a big Lindsay fan, and I saw, wow, this is this really smart girl who's like, can I call you that? Who's
Well, thank you.
who's like doing stuff on Canadian law, and that's how I reached out to you, and we got to know each other a bit. But anyways, Lindsay made a really good point, which is that we could be mindful for watching how they try to actually change the rules on these kinds of issues, soften things and kind of undermine our freedoms and autonomy, which is how I see it all. But what's really terrible is that they'll just water down the meaning of words. So you'll have the same structure, the same rules, but the words themselves change in meaning, and it guts all of the constitutionally protected things. And I think
the key word, the most concerning word that's being altered is the word equality. And there's a lot of litigation going on around in Canada. It's Section 15 equality, but I wish they would use the word equity, because that's what they're talking about. But they're trying to pretend that their equity goals are actually equality goals. And I was actually just sharing a decision from the Supreme Court. It was actually a dissent, though. Justice Brown, he's had so many dissenting opinions recently, but he had a really interesting dissent in, I think it's Fraser versus Attorney General of Canada, about job sharing and whether it was discriminated against women who tend more to job share than men do. Right. And he talked about being frustrated with this idea of substantive equality becoming a catchphrase to, it's just a form of rhetoric now that's being used to try and advance a bunch of goals that are activist goals that aren't consistent with the charter. So, that's, and it kind of ties back to what we're talking about with pronouns too, because it's my understanding that the demand for pronoun usage is a charter request. They're saying this is, I have a right not to be discriminated against under gender identity, that, that this is my charter right to be referred to by the pronoun that I wish. And that's an equality right.
So has that been litigated yet? Have people kind of tried, that sounds like Bill C-16, right? And someone trying to defend or justify C-16. That was the pronoun one that you're right, Jordan Peterson really first took issue with and drew everybody's attention to. And I think that expands the notion of rights, that you have the right to put words into other people's mouths. And
that was their counterclaim, was that, it's a positive right. And, I find it difficult to explain positive versus negative rights because they are kind of counterintuitively named, right? That's right. So the positive right is the right to demand something from other people. And so that's the gender identity. I demand respect from you. Whatever I tell you my gender identity happens to be, you have to respect that. And they're saying, well, I have a negative right not to be compelled to do something. And in which case this was compelled speech. And then the problem is that I don't think they really examined the depth of both those arguments and assessed it properly in terms of positive versus negative rights and where to place limitations. Because really what they looked at is all they want is respect. Yeah. And you're just talking about speech. And so they didn't understand the importance of the speech argument, I think.
Right. Yeah.
Not to age myself too much, but I've been misgendered a number of times in my life. I think it happens to everybody. Just like for whatever reason, somebody's not paying attention and they're walking up behind you and say, "Excuse me, sir," or something like that. Yeah. Or, you know what I mean? Like, which would be considered an egregious misgendering now. But it's really just somebody not paying attention most of the time. But in the 80s, I was really into the alternative goth scene, and androgyny was a big thing. But that androgyny didn't mean that you can't refer to me as a certain pronoun. It just meant I don't care which one you use. Like it was kind of fun to have people being a bit confused, But
and thinking back to like the I'm older than you, and like the late 60s, Vidal Sassoon, unisex shampoo, unisex pantsuits.
That was actually a big deal when they had unisex clothing stores, wasn't it?
Yeah, that's right.
Or like they had,
But
I don't know. But
nobody got bent out of shape because it was all like fun.
That's the thing, is that it was fun and everybody was open and receptive to it. And they're just like, okay, this is interesting. But then at some point, it got really angry and aggressive. And I have no idea how to pinpoint exactly when that moment was.
Well, we have no generosity left. I mean, generosity is suspect in itself. And here's where I'm so grateful for everything I've learned from Lindsay and Helen Pluckrose and Bogosian and all of those guys and so many others now, about kind of the large progressive woke march through our institutions and our culture. And the idea is they don't want, okay, here's the point I want to make. Let's say everybody complied perfectly with this new gender scheme in the British Columbia courts, and that's not happening. And that was one of the things I tried to warn the judges about. You're going to have these directives that a whole lot of judges and certainly a whole lot of lawyers aren't going to want to comply with. And now you've got these kind of directives that are sitting on the table, not being followed. And that's got to undermine respect for the justice system generally. You don't want that kind of thing. You don't want orders out there that people are ignoring. You better not have the order. Anyways, if alternatively, if everybody followed this stuff and completely absorbed it, I think that, and maybe I'm wrong, maybe I'm just suspicious, maybe I'm just some sort of like old, white guy thinking this, but I think that that would not be very satisfactory for this woke lobby. They want the frisson. They want that little bit, they want the struggle. They want examples of people that need to be corrected. And once, if they got all of that, they'd want something more because it's an agenda to, I'll say the big picture. They want to undermine our society.
There's observations we can make, and that's that a lot of these requirements and these new demands seem to be enforced by choosing people as sort of figureheads to attack and to make examples of. And that by introducing something that's actually not just a preference to comply with, it's difficult to comply with because these, it's going to become, it's not difficult with trans people. That's pretty easy to remember. But, aside from the issues where if somebody transitions their gender from a time of an event to the time of a trial, but so that can get more complicated, but it seems to me like a setup so that if there's somebody who they don't like for whatever reason, they can try to catch you making an error and then make an example of you and then remove you from your profession.
Yeah.
That's,
right.
Potentially a slippery slope. The interesting thing with the slippery slope is that it's a logical fallacy, but it's also a legitimate concern that, something starts in one place and then it can easily slide into another one. So, if you get too dramatic with what you imagine that slope to be, then it can become a logical fallacy. But we do have issues in law where you can make constitutional challenges, not just based on your own client, but based on a proposition of a potential occurrence of another scenario.
Great observation. And why don't you just flesh that out a little bit further and explain that concept? Because you're absolutely right. It's an interesting thought. But what you mean is that if you're challenging the constitutionality of the laws that applies to you in your case, you're entitled to take a more general run at that law by posing a reasonable hypothetical that might not even be your case, but it could be another reasonable fact pattern that just illuminates how unconstitutional that law is. And you're allowed to do that.
Right.
Okay.
That's the word I was forgetting, the hypothetical.
Tie that in here.
So, just like we were talking earlier about how it starts out with a demand for, respecting an obvious gender change. Well, nobody has an issue with that. Then asking for plural pronouns. And then everybody makes a lot of effort to figure out how to do that. But then now we get these noun pronouns. And so then we have people who want to be called judge. And it sounds absurd. And this is the problem too, is that the stuff does move so rapidly. If you were to be in court putting this reasonable hypothetical, it would be deemed unreasonable.
That's great. You're absolutely right. We talked about this earlier and it's the same thing. You're right. The margins of reasonableness that in itself is suspect. It's considered part of like our white post-enlightenment kind of hyper-rational society. And so because of that, the idea of like something that we would laugh at Like, for example, being offended by the word transcript could tomorrow be like a real thing. So the reasonable hypothetical, the boundaries of that are like through the roof.
Yeah, I know, but then nobody believes it until it happens.
Yes.
And, so it's almost like we have to have these conversations and then put a record down. So, but I did see a case actually on a different issue where it was deemed to be an unreasonable proposition that a husband would be removed from his profession for giving a massage to his wife, right? That was a proposed proposition.
Yeah.
And it just happened. Like,
No.
yeah,
Tell me about it.
There was a case where a guy who was a massage therapist, it was determined that he was giving massages to his wife and at home, and she wasn't a complainant.
So what's the problem?
He wasn't permitted to do it.
They have a
He lost
personal
his license.
relationship. They have a personal relationship, and he's using his professional sanctified tools, i.e. his hands,
Yeah.
to touch in an unprotected environment, unmonitored, unprotected environment, a whole other person, probably someone of like a kind of identified disadvantaged group, i.e. women, who just happens to be his wife, that he, oh my God. And so what happened?
And the wife was not the complainant. He lost his license.
Right. Fuck.
Yeah.
You're kidding.
I know.
This is all.
I wish I was.
This is all Dr. Seuss stuff. Oh, wait. Yeah. So.
But clearly somebody had it out for him, and that's how it came to the attention of the licensing board. So that's the problem too with these
What
things.
happened? How did that get resolved? Was there nobody on the massage board or whatever that said, "Hey, wait a second"?
They just said technically he's violated the rules, and so it was a rather dramatic submissions after the finding was announced and so on, and sort of closing comments made by the man's lawyer, which were quite well written.
Has he gone to the courts? I think he'd have redress in the courts, right?
I don't know how it got followed up on, but that's
they're chipping away at common sense. They're chipping away at our notion of common sense. Everything inherent that we have that either we were born with as a reasoning property, or certainly that was nurtured and cultivated in our early years, that forms our common sense, that is what's being threatened. And we're not supposed to have that common sense, which really expands the scope of your reasonable hypothetical, but makes life shitty.
Well, I think it's a common phrase saying my pronouns are not up for debate. So the ability to even have a discussion about whether or not, the pronoun issue would have any negative effects or cause any undesirable, sort of ridiculous circumstances, which are proper discussions to have in a court of law, that even trying to have those discussions is deemed to be an outrageous thing to do because you're debating their pronouns.
Well, let me tell you what happened with respect to that. In this case in particular, it's exactly what happened here. So a really smart young civil lawyer who I kind of came to meet over this issue, BC civil lawyer, she wrote an article for the British Columbia magazine, the Lawyer's Magazine.
Shut in.
Called the.
You're talking about. Yeah, it was a great article.
It was a great article. And they were going to run it, but they wanted to just kind of run it by Sojik first, which that puzzles me because Sojik is not, as I said before, they're not a stakeholder in my words. But anyways.
Journalistically, I can see giving somebody a right of reply if they're mentioned specifically, or if they're known to be behind a subject that's being criticized, then it's good practice to ask somebody if they want to reply, not to let them edit your article, but without seeing the article, ask if they want to make a statement, for sure.
Fair enough, and that's a good point, but I don't know that that they were actually even named in her article, but they might have been, and they certainly were behind the whole program that she was critical of. So, okay, fine. So the advocate reached out to Sojik, and then it ended up saying, even though they're very enthusiastic and it was a really good article, they said, no, we can't run this. So they got scared off from running that. So then she submitted a shorter version to a national lawyers magazine called Canadian Lawyer. And they did print her article, and what happened was it incited or provoked an open letter from 216 lawyers, many of them prominent from across the country, who wrote just calling her all sorts of names, saying that she obviously had no respect for the lives of trans people. It's kind of like the Peter Pan principle that if you don't say something nice about fairies somewhere, as Tinkerbell said, there's a fairy that dies every time you say you don't believe, or something like that. But they're making this point, and they said that there's nothing to talk about here. And they're not going to be dragged into this terminology they use. We're not going to be dragged into a debate over the legitimacy or the merits of these new directives. There's nothing to talk about here.
Well, there were some personal attacks that, the article that I saw was properly written, identifying specific concerns that are relevant to the legal process, and to respond to that by with personal attacks, calling somebody transphobic, and the type of insulting response that they got without addressing any of the merits, or explaining why there was no merit. That's
part of their woke agenda. The idea is that there's nothing to discuss here. They're not coming in on a fair level, civil playing field. We can discuss this. That, I think, the idea that these directives came down in BC without any consultation, without any notice to the rest of us, until they just kind of plopped down, that's not a bug, that's a feature of the program. The idea is that better minds, better hearts have kind of all come to terms on this, and they're going to lead us out of the darkness, and our common sense and our own kind of conventional ways and our wishes be damned. And so, yeah,
I've seen that before mentioned in the crafting of bills and so on for legislation, that they have meetings with stakeholders, and you don't know who those stakeholders are, how they got invited, or whether the stakeholders were actually fairly representing a broader perspective, or whether they were all stakeholders with the same viewpoint. That
exactly.
I think the transparency is a legitimate issue. That but maybe it's
you did it again. You just did it again. Anyways, go ahead.
The transparency.
Okay.
It's I think the problem right now is that they're not understanding the bigger impact of it, and recognizing that it is something that needs to be discussed in more detail, and that there's a lot of considerations and predictive, sort of those hypotheticals have to be put forward, with an understanding that what might seem insane as a hypothetical is actually something we're watching happen on a regular basis. Not to suggest that any judges should ever go to Twitter, ever. But if you even briefly look in on what's going on there, and to be honest, I think that judges are aware of things that go on places like Twitter, because you can see it in their decisions that they're addressing, public concerns about various things. And so they must know about those public concerns somehow or another, right? And it is having an effect. And I think right now, my biggest concern is I want to protect judges from being unfairly attacked, because unlike you and I, who can speak or write an article or something, and other members of the legal system, judges aren't permitted to make public comment. So there has to be something to protect them and keep them in a situation where they can make proper, logical, neutral decisions.
So in this, you're absolutely right. In this case, what I think happened is that the judges were tricked into thinking that this is safe territory, that this is almost bland and non-controversial. We'll just get everybody to kind of do this little bit of kabuki theater. We'll all kind of offer pronouns, and it's very safe. They didn't realize that they were being dragged into, they should have realized, but I don't think that they realized they were being dragged into a very contentious, controversial kind of territory. And I don't know, I think they're stuck now. I don't know what's happening with the judges here. They're gonna.
I think we can be a bit more positive, because there's times where decisions have been made on constitutional issues and the challenge fails, and then a new situation arrives. And if you get a situation that brings up new subject, or like new evidence, or something changes in a significant way, then they'll revisit the decision. So I
But
think
those are
there's still,
legal decisions. This is like a backroom kind of judicial decision that, I mean, there's no venue to appeal it. I don't know how you could ever contest this legally. How do you,
well,
well, what court
the
would you
legal
go?
term is, how do you get standing, right?
How do
So
where would you want standing? Would you want standing here in BC to go after the BC judges' directives? I don't, normally people were expected to have like a common sense of civility and kind of norms so that we wouldn't have this kind of problem, so that it's safe for the judges to come down with the directive, that everything's going to be reasonable. They think that we should wear our Supreme Court clothes for pretrial conferences. That's reasonable. We don't have to have a venue to litigate this. But now they're coming in with this searing, kind of invasive and divisive thing. And yeah,
you know what it might be? It might be a situation where somebody will get standing because they'll lose their career or be disciplined for failing to comply with something. Yeah. So it's possible, but I don't know. It seems like some pretty crazy times, and not crazy because of, well, some of the pronouns that I'm hearing about are kind of crazy. Not crazy because the subject has come up, but crazy because we're not supposed to actually even be talking about it. That's deemed to be improper. But I think like the conversation like we just had, I really don't see how anybody could be offended by it. I mean, there's logical considerations and proper conversation to be had about it. And it used to be, okay, here, I guess here's where I'm trying to go with this. It used to be that an advocate used to explain things to people. And now they say, it's not my job to educate you. So I think maybe that's what's missing, is that we've reached a point where people who are demanding certain things, getting laws implemented or regulations implemented, don't want to tell you about it because the current idea is that it's not their job to educate us. And then we're called idiots because we have questions.
Yeah, they never would have passed this. This would not have gotten past go had there been kind of an open consultation process. They wouldn't have been able to persuade enough people that we should do this. So that's how they slipped in this way. Yeah.
Not in the broad sweeping way that they did it. I mean, certainly like we mentioned at the beginning, nobody's had a problem with actual transgender people saying, I'm now of a different gender. It's always been accommodated, where they try to make sense of it and deal with the cases where it does create complications. There was no evidence that people were being disrespectful. So
no, there wasn't. That's all trumped up.
Yeah, we'll find out.
You don't walk down the hallway of a courthouse in British Columbia and see transgender people, lawyers or civilians kind of crying because they were just abused or misunderstood or outed or something like that in court.
By a pronoun. Yeah. I know. Well, at the very least, I really wish people that said that they are a plural would start calling themselves we and us. Because if they want to inconvenience everybody else and actually understand why it is we're having trouble using a plural, then they should actually try to use it themselves. So I don't know how seriously I take people who use plural pronouns unless they actually apply them to themselves as well. So that's sort of my most controversial point.
Oh, I see what you're saying. That's a good point. And
otherwise, it's just they're laughing because look at how I'm making everybody else jump through these hoops and I don't have to do them myself.
Diana, that's really good. That's really good. The idea that someone
shows
wants
they're serious if they're actually doing it.
In which case, what is that, like the royal we?
Yeah, they've misgendered themselves if they say I.
Yes, that's good.
I know. All right. Well, it's great chatting with you. And we always end up talking for ages. There's so much interesting stuff going on. Of course, I was out in BC before, and now being in Ontario, you keep me up to date on everything that's going on that I'm missing out on. So
it's been great. Nice talking with you. Let's do it again.
Yeah, definitely.